Anna Edie for Ms. Torrance.
We have reset this thing at least 4 different times, I would imagine, because of this bond violation. One, I guess, evidentiary reason for Ms. Edie to get evidence. Last time we were here, we were going to have a hearing. Unfortunately, we didn't have our pretrial services officer here. She's here now. So that's why we're having this hearing now to determine whether there is a true bond violation. Ms. Torrance is on bond for a DWI that was initially filed August 28th of 2024. It's a second offense. So she was ordered to obtain a guardian interlock, or if she was not going to drive, obtain a portable device.
All right, so here's the setup. See,
Okay, courtroom watchers, buckle up. This isn't your run-of-the-mill hearing. This is a ticking time bomb wrapped in breathalyzer reports. Think she's just being careless, or is something deeper going on here? Let's find out.
According to the below schedule. Our first bond violation report was filed October 8th of 2024. And I'm correct in saying that no action was taken on that bond violation.
She was admonished and
I admonished her. We did not do anything at that time. We now have another bond violation report that was filed January 24th of 2025. And in this bond violation,
13 missed tests.
Missed tests aren't just oopsies, they're breaches of trust. And in the courtroom, trust is currency. The question is, was this a misunderstanding or a full-blown disregard for the rules? Sound off in the comments. How would you handle this if you were the judge?
on random days. And then I think that there were other issues as well, but I guess for me, the main concern would be that she's not testing when she's supposed to.
Okay.
The floor is yours, Miss Edie, if there's anything that you wanted to say.
Okay, well, let's see. The only thing I see alleged in the bond violation report is just the skip test. So I just want to make sure we're all on the same page. I don't know that there's any other allegations.
Okay.
That's correct. Okay, okay. This is not my hearing, Judge, so I don't, if the state wants to call somebody or, you know, they have the burden, so whatever they want to do, I'm happy to respond, but this is their.
So tell me what happened with the missed test, if you don't mind.
Yes, Your Honor, we can call pretrial services Miss Felicia Chiles if she is available for one moment.
Okay, do you mind coming up? Raise your right hand, please. You solemnly swear to tell the truth, the whole truth, and nothing but the truth.
Quick legal sidebar. When a court takes judicial notice, it's basically saying, yeah, we already know that's a fact, no need to prove it. But here's where it gets spicy. Just because something's in the file doesn't mean both sides agree on how it should be used. Welcome to the chess game of the courtroom.
State.
Judge, would you please take judicial notice of the court's file, which is a copy of the information?
Okay, any objection?
I'm okay with the information. I would object to taking judicial notice of the report.
Okay,
So I'm not sure what all is included in the file.
We were addressing about the defendant here being charged. That's why we're asking for judicial notice of the court's file regarding
Okay.
that element that we need to prove today.
sure.
So,
All right, Ms. Chiles, Giles, apologies. Is the defendant on bond or court of law number 5?
Issues?
Yes.
Yes.
Are you familiar with the bond conditions?
Yes.
Your Honor, may I approach?
Yes, sir.
Is this a fair and accurate representation of the bond conditions for the defendant?
Yes,
You recognize that?
yes.
What is it?
They're the magistrate's conditions for the defendant.
In order to the defense, Your Honor?
Okay, please. Any objection?
No objection.
Okay, they'll be admitted. States 1, I guess.
yes, sir.
Okay.
Could you please describe the bond conditions?
Yeah, you want me to like read all of them? Or like all of them?
Yes, we don't have to check.
Yes. So we have defendant shall personally appear in court on time every time the court
this case is set on the court's docket unless judge waives the appearance. Defendant shall commit no crime or shall not engage in any conduct that could result in his or her arrest. We have here that they're to obtain an ignition interlock device within 7 calendar days. Is this the most recent condition? Doesn't she have a portable device? The device. Are these the most recent conditions? Because these are the IID ones. Can I have a moment to look at that?
Sure.
Yes, please.
These are not the most recent bond conditions that are in place. These are the first ones from the magistrate. Right now I'm printing out the amended bond conditions that were created on September 4th, the ones that we're referring to with the portable device. So the first two conditions are the same that I had stated. However, instead of the ignition interlock, we have the client is to obtain a portable device within 7 calendar days. And that would be from the date of August 28th. And then no driving without permission of the court. We have no drug or alcohol usage. And then that same day, the defendant also was required to submit to a POC test and return to court.
Your Honor, would you like me to tender these updated
Sure, of course.
with amendments?
So two, I guess states two would be the amended conditions of bond.
We're calling this stage 3, if that's okay, Your Honor.
Okay, sure.
And I have no objection to this.
Okay, it'll be admitted.
Now we will be addressing the bond violation report.
Your Honor, may I see this witness?
Sure.
You recognize that?
Yes.
Is that called?
This is the bond violation report?
The fair and accurate representation of the bond violation report.
Yes.
All right, could you please explain the violations of?
Objection, she's reading from something that.
And boom, credibility hit. The key witness can't explain how the portable testing device even works. That's like accusing someone with data from a mystery machine no one knows how to operate. Is this justice or just procedural theater?
Please tender this to the defense.
Oh,
This will be admitted as State's Exhibit number 2, Your Honor.
Okay,
no objection.
all right, it'll be admitted.
Can you please read where it says details of violations indicated here?
Yes, the details read that the defendant was instructed to obtain a portable alcohol testing device and refrain from alcohol consumption. From December 9th to January 14th, the defendant has generated 13 skip tests. Pretrial is unable to properly supervise the defendant if the defendant is failing to provide samples during the scheduled timeframes.
But wasn't it a condition of bond to complete those portable tests?
Yes,
And how many again were not completed or were missed?
13.
And what were the dates?
Between the dates of December 9th and January 14th.
Thank you.
Any further questions for the witness?
No, Your Honor.
Okay.
Do they prepare a report of the missed blows with the specific days? Yes, and that was provided to everyone here's email last week or the week before when we had discussed it. Okay. Ms. Giles, what is your job title, exact job title? Judicial Liaison Officer. And what do you do as part of your regular duties? I am the face in the court for pretrial services. So I create bond conditions that are requested from judge and instruct clients over things that I can instruct over. So conditions that don't require devices in court. And if not, I send them over to our pretrial services building for further instruction. Okay. Do you know how the portable device works? I'm very partially familiar, but not thoroughly, no. Okay. Do you know how the software in the device works? No. And do you have any idea how those work together? No. So when you get a report, you have no way of verifying whether that information is accurate.
The vendor sends us the full report to our case managers.
And was the full report provided in the email that you referenced earlier?
Yes.
Okay, but there's no way to know that that device is working properly from your personal knowledge.
For me to validate if it's working
Mhm.
correctly, me personally, no, but our case managers do verify it.
Okay, I don't have any further questions for this witness, Judge.
Okay. Anything further?
No, Your Honor.
Can the witness step down?
Yes.
Okay, thank you so much. All right, I guess argument. Or do you have any more witnesses?
No, Your Honor.
Do you have any witnesses?
I do not.
Okay, argument.
So, Your Honor, this case is pretty clear. It's a simple bond violation. The defendant here was in fact charged. We ask you to take judicial notice of that fact. And we have proven such, and that this defendant is on bond in County Court at Law number 5. And we just discussed the bond conditions that were pretty standard. And the violations here very clear that there were 13 missed portable tests. And our pretrial services was able to confirm that. And we would ask that you would revoke the bond in this case.
Judge, this is, the rules of evidence apply at this hearing. This report is testimonial. Since it is testimonial, I have the right to confront someone with knowledge about whether the machine itself was working properly, whether the software was working properly, whether the two were working properly together. And we reset this to today to get someone here who had that knowledge, was my understanding. And without that, I can't.
I didn't know about that. The only one that I knew that we were supposed to have here was Ms. Childs as with
Yes,
regard to
Your
this, not anything else.
Okay,
All
well-
in- okay,
And we
go
would
ahead.
say that the defense also has the ability to subpoena